for clarity, not even the Speaker of the National Assembly may discharge the functions vested in the Deputy President under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the Deputy President will remain vacant except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position that the office of the Deputy President cannot be left vacant is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the Deputy President, has it that the provisions of Articles 144 and 145 relating to the removal of the President shall apply with the necessary modification to the removal of the Deputy President. Returning back to Article 146, which article deals with the vacancy in the office of the President. Sub-Articles 1, 2, and 3 of that article provide as follows. This one I'll read. Sub-Article 1, the office of President, Deputy President, shall become vacant if the holder of the office dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of President on grounds of incapacity, or Article 145, which deals with removal of President by impeachment, or under any other provision of the Constitution. Sub-Article 2, when a vacancy occurs in the office of President or Deputy, 1, the Deputy President shall assume office as a President for the remainder of the term. 2, if the office of the Deputy President is vacant or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of President shall be held within 60 days after the vacancy arose in the office of President. Sub-Article 3, a person who assumes the office of President under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected President is sworn in following the next regularly scheduled election under Article 136, Sub-Article 2A. End of Sub-Article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the Deputy President in this matter, yields the meaning that the person who assumes the office after the impeachment of the Deputy President shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the President ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the Deputy President will always be filled except during the brief period of required to fill the vacancy as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gachagua, Peter Munya, and Dixon Mwenda Githinji and 2 others say as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, Sub-Article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the Deputy President shall cease to hold office, end of quote. 2, additionally, the prevailing status quo will mean that the Deputy President nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, The unique nature of the deputy president role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the deputy president vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the deputy president under Article 147, Sub-Article 2, once those assigned by the president revert to the president in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such an outcome is clearly not envisioned by the document itself. The Constitution was not handed to Kenyans on a silver platter. No, it was achieved through great struggle and sacrifice. Therefore, it is the duty of the court to uphold its provisions as intended by the framers and as demanded by the people of Kenya. Furthermore, Article 259 of the Constitution mandates that the document must be interpreted as always speaking. This means the Constitution is a living document designed to address contemporary challenges and to be applied consistently and continuously without interruption. Suspending any provision of the Constitution, even temporarily, will undermine this principle by creating gaps in its operation and disrupting the intended balance of governance. The Constitution is structured to ensure that all its provisions are effective and operative at all times. If any provision, such as Article 147, Sub-Article 2, is rendered dormant by a judicial order, it risks setting a precedent where parts of the Constitution could be selectively switched off, effectively weakening the Constitution's authority and the protections it affords. Additionally, we are mindful that courts are guided by the principle of constitutional supremacy, which requires that all judicial decisions align with the Constitution's objective and upholds its integrity. Issuing an order that suspends a constitutional provision would directly contravene this principle, effectively placing judicial discretion above the supreme law of the land. This will be inconsistent with the spirit of judicial restraint and the court's role as a protector and not a modifier of the Constitution. For these reasons, we take the position that the Constitution must remain fully operational at all times, and no court order should have the effect of rendering any part of it inoperative or dormant. The court's responsibility is to interpret and apply the Constitution as a cohesive functional document that serves the people's enduring will and protects the structure of governance as established. Drawing from the above, we hereby find and hold that public interest in this matter favors giving way to the Constitution, which in any event is the will of the people. That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the consolidated petitions will be rendered inevitable in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Getu Mugai, has given an undertaking to comply fully with any orders which would be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
This position, as we conclude, we that this matter holds significant public interest, and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be in course. We grant leave for appeal, type proceedings, and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
Most obliged, my lord, and I have an badge of pride, my lord. We want to
thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my lord.
Thank you.
My lord, my name is Ochiel Dudley for the Deputy President, and I wish to make an application. The application I wish to make is called the Madhu Pepper Injunction. And Madhu Pepper International, quite a famous case. In the common law, it's called the Eringford Injunction. My lord, the Madhu Pepper Injunction operates on quite a simple premise, the premise of human fallibility. In the case of Eringford, where that injunction originates, Justice Megari, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Here, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings. And that application comes up on the 6th of November 2024. My lord, operating on the premise of human fallibility, the foundation of the Eringford or Madhu Pepper Injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal will be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even where he needed none, we ask you to issue a Madhu Pepper injunction. We do not seek an indefinite injunction. we seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, my Lord.
We also have a moment by the chair.
The Black Bull, okay.
Yeah. My lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon? Rule 23 and Rule 24 of the Mutunga Rules. I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this honorable court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Lordship, Article 10 of this Constitution, of the Constitution, by this honorable court to observe the rule of law. It further calls upon this honorable court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission, Mr. Jero has referred to an application for which he's seeking some orders pending, but we haven't seen any application to that regard.
Yes, Your Lordship, if Mr. Kamoso was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
If I may, I respect my learned friends. Madam, I respect... Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. So I'm going to sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my learned friend is referring to the exercise of this court of a epistolary jurisdiction, then you should say so. But you cannot refer to the exercise of that jurisdiction, my Lord, when this court is found as officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served or last, or two, my Lord, because there's already an application for stay under Section 5(2)B of the Appellate Petitions Act before the Court of Appeal that is live and that has a date, this court will not have jurisdiction to entertain any other application for stay. They tried making an application for the Court of Appeal this morning using the same issues, my lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So my lord, for my friend to come here and to seek to apply for stay again, having a second bite at the cherry, it is honest, my lord. It is honest. They are before the Court of Appeal.
May I suggest, Professor General, that could be your response to the application which will be made by Edward?
Yes, if there's an application here.
Thank you, Your Lordship. Your Lordship, permit me to move on with my application. And I ask Professor Ojenda to have a look at the rules that I've just referred to. But Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the President or the Deputy President must attain if one is to hold office. Ladies and Lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies and lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Lordship, the President indicated that he had had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. Ladies and lords, when the President of the Republic referred to the IBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. Ladies and lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC.
My lord,
Or no, my lords?
my lord, may I just seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our clients. So we're seeking that we get a formal thing that will enable us to seek instructions from our clients. Dr. Kamodo for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IPC to confirm whether Professor Kithure Kindiki is a registered voter, that would mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordship. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Gidero, my understanding,
Yes, Your Lordship.
when you first asked for this conservative
Yes, Your Lordship.
under Maggie Pepper,
Yes, sir.
it
That
was
is his application. I have on a different application. I moved under
because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another aid.
Your Lordship, I am well guided.
So I think for the purposes of the discussion of the bench, for the purposes of the discussion of the bench,
Yes,
I think Mr. Ochien's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24 that due to the vulnerability of the rights and the vulnerability of the infringement and violation of the Constitution, I can appear before you.
The rights cannot be vulnerable. Individuals are.
May I have
No
my
rights.
time and then you have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as a payoff, it is all clear to us that nobody can deny, not this court, not myself, nobody can buy his head under the sun, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the freedom of the people? Your Lordship, I beg that you hear us. I beg that you grant the confirmatory order staying the swearing in of Professor Kithure Kindiki on the basis that he is not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become the deputy president, a bankrupt person can become the deputy president. I rest my case.
All right. Let me respond to.
And every other council who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretionary. So I'll only allow one response, and then we'll render a ruling only one response.
Yep, my lord, if I may respond to that. My lord, you made a ruling.
Okay, let's make a ruling. We are two people from this side.
And two from you're one person.
Dr. Kamima, please say what you want to say and be mindful of time, please.
Justice Eric Ogola, Justice Anthony Murima, and Lady Justice Frida Mugambi have listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done so. You have developed the students of the country. But there is one thing I would like to point out to you very respectfully. That we are operating in very dangerous waters with strong currents. And this is an area where we have to call for wisdom. We have to call for deeper understanding of human nature and for deeper understanding of the society in which we live, Kenya. And what I'm saying to you is reflected in my broad feeling of the authorities in cases in the United States of America. Your Honor, if I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for books from India straight about 11 volumes on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law?